Joining us now is national security lawyer Brad Moss. Welcome back to the show, Brad. Appreciate it.
Absolutely. How you guys doing?
We're great. So, Brad, give us your breakdown of you've been following these cases in and out for a number of years. That's how we got to know each other. Your initial read of the potential Alvin Bragg indictment of former President Trump.
Sure. So I'm a little surprised this one's coming first. I was almost convinced the Fulton County one was going to be happening weeks ago. Fani Willis has clearly got some stuff that she's working through, and that's fine. But for the New York case, look, we all remember this story. It came out a bunch of years ago. It was this whole thing about how he paid off Stormy Daniels in the final days of the 2016 campaign, covered it up through payments through the lawyer, and then later on, his lawyer went to jail over it. It's a very interesting case because there's going to be some untested elements to it. There's going to be the issue of statute of limitations. Normally, we'd be long past that, but New York has a particular provision that allows the government to toll or extend the statute when someone has relocated continuously outside the state. Donald Trump did that. He lived in D.C. and then he moved to Florida. There's going to be the issues of venue. He's going to say, everybody in Manhattan hates me. He's going to say, I can't get a fair trial here. Yeah, that'll be a nice argument. But if it didn't work for the January 6ers in D.C., I don't really think it's going to work for a lifelong New Yorker getting tried in Manhattan. And then there's the last part is he's going to claim that this is being overcharged, that it should just be a misdemeanor of anything on falsification of business records, that the state, campaign finance issue has never been tested. And that's true. It's never been tested. But every crime that's been prosecuted under a particular statute at one time or another had never been tested. This will be the first if this is in fact what happens.
Let me push you on that part a little bit. David French, certainly, who's now a New York Times columnist, certainly no fan of the former president. He's out with a piece that questions exactly that aspect here. In his tweet about his new op-ed, he writes, untested legal theories should not be used to prosecute anyone, including and perhaps especially former presidents. I added that perhaps especially for those who are just listening. What do you think of that particular argument, Brad?
Oh, like I said, one, there's always going to be a first for every case, a first for every type of criminal prosecution that's happened. Originally, there was always a first time for all of them. But here's the part that I really dislike about some of those comments, and I've seen the ones from David French and others. They keep referring to Donald Trump like he's special because he's a former president. He's not a president anymore. He's a simple private citizen. He is not special. He's no different than you or me or anyone else who's an ordinary private citizen at the moment. If he becomes president, he has all kinds of protections then. But until that time, he's just an ordinary, average American citizen subject to criminal laws like everybody else.
So, Brad, one discussion here is about that you alluded to is that when you're a private citizen versus president, some of the treatment does actually change. So some reporting has indicated one of the reasons that Trump does want to be president again for a variety of reasons is actually he would receive legal protection. Can you go into some of the analysis on that? I know that you covered it quite a bit at the time. What legal protection does a current president actually have while he is in office, especially as it would relate to such crimes like this and perhaps even the Fulton County one?
Sure. So it's nothing written in law. It's nothing written in regulation. It's a Department of Justice policy that the Justice Department, at least, would not indict a sitting president. Not because they couldn't, but because of the constitutional ramifications, the disruption it would have to the chief executive's abilities to perform his duties. They said, we won't do it. That dates back to Nixon. It was that guidance was updated during Clinton's time, and it's never been changed. That's one of the reasons Mueller didn't do anything with respect to the obstruction angles that he thought he could have pursued because he felt he did not have the authority to bring an indictment of a sitting president. If it was up to anybody, it was potentially up to the attorney general or Congress to impeach. So if Trump gets reelected, he'll have protection from whatever's going on with the special counsel probe, any other federal investigations. But it's completely unclear what that would mean for Fulton County and what that would mean for Manhattan, because obviously neither of them report to the Justice Department. Those are local state entities, and there's no theory, there's no precedent, there's no case law to look back at to say here's how it would work. We don't know because former presidents generally don't get prosecuted because they don't do this.
Yeah.
Got it.
Let me ask you about another piece that people have been questioning. Some analogies have been made to the John Edwards prosecution. There was kind of a similar dynamic. He had a mistress. I believe it was campaign funds that were used in a sort of similar cover-up type of a fashion. Let's put this up on the screen. This was an analysis from Jonathan Turley that was written in The Hill. He says it is extremely difficult to show that paying money to cover up an embarrassing affair was done for election purposes, as opposed to an array of obvious other reasons, from protecting a celebrity's reputation to preserving a marriage. That was demonstrated by the failed federal prosecution of former presidential candidate John Edwards on a much stronger charge of using campaign funds to cover up an affair. So basically what he's saying here is, they would have to show, in order for this to be a felony, is my understanding, you can correct me if I'm wrong, I'm not a lawyer, far from it. But for this to be a felony charge, they have to basically show that the business fraud was in service of covering up this campaign finance violation. And to show that, you have to prove that this $130,000 was really about the campaign and not about, protecting his reputation or preserving his marriage or whatever else they're going to argue in court.
Sure, and that's a fair comparison for Turley and others to make, and I'm sure that's something that's going to be brought up in pretrial motions by the Trump legal team, saying that this is, there's no basis for this. It's not, relevant as a matter of law. But here's things to remember. One, that was a federal case dealing with federal campaign finance laws. This is going to be a state case based off New York state law, so they're not directly comparable. Two, with Edwards, it was a mistrial. They could have retried it. They had reasons not to do so, and understandably they did not, but they could have retried that case. Three, that was use of campaign funds in the Edwards case. This is use of private funds in the days before the election through a third party. It's unclear, and I'll give this, Alvin Bragg's got his work cut out for him if he brings this indictment, but it's unclear if the Edwards case would really have played out differently if it had based on New York state law. We just know.
Right. That's a great point. And then finally, really, about the talk of state versus federal. Initially, federal prosecutors, while Trump was president, from the FEC and others, decided to go after Michael Cohen on this, but decided ultimately not to go after Trump. Will that factor in any way into the state case? And is that an argument that the Trump lawyers can make?
It's certainly something they can raise in the context of, selective prosecution and things along those lines for a pretrial motion. But here's also to remember. When the case against Michael Cohen was originally brought, Donald Trump was president. The Southern District of New York could not bring a case against Donald Trump. They had no authority to do so under that existing DOJ guidance. The only thing that could have happened is they could have theoretically brought a case once Trump left office in 2021. We don't know for certain why they didn't do it. Maybe they thought the case was weak. Maybe they were worried about, and in a number of factors, maybe they thought January 6th was just going to take them down. Who knows? That's not dispositive.
Okay.
And one more last question for you, Bradley. Sorry. What do you make of, it's no surprise that Trump would argue this is politically motivated, but, what is your read of his claim that Bragg basically ran in order to try to bring these indictments and that, this prosecution wouldn't happen if it was a Democrat who was facing similar charges?
Yeah, this is a tried and true method for him. He tried this in the Letitia James case. That's still ongoing against his corporation. He tried that in that civil litigation, saying she ran for the purpose of taking down Trump. The judge rejected the argument. And here's the best part for people like Alvin Bragg. They have a Supreme Court precedent they can point to in the context of no matter what I said on the campaign trail, it doesn't matter if I can point once I'm in office to a legitimate independent reason for having pursued this. It's a case involving Donald Trump and the original Muslim travel ban. That was how the government managed to get the third version of that travel ban through the Supreme Court, was by saying, we don't care what Trump said on the trail. All that mattered to us was what we did once he was in office and how we based it in facts once he was in office. And the Supreme Court went along with that.
Gotcha. So from a political talking point, it may have some legs, but from a legal standpoint, perhaps not.
Yep.
I don't think so, no.
Got it. Well, Brad, that's why we appreciate it. I know you've got your view, but you are fair in your judgment. You always have been, and we'll continue to have you back on the show.
Yeah, we appreciate it,
man.
Anytime.
Hey guys, ready or not, 2024 is fully upon us now, and Saagar and I have been brainstorming ways that we can really up our game for this critical election.
Yeah, we rely on our premium subs to expand our coverage, to add staff, to upgrade the studio. We just want to give you the best independent coverage of this election, which is possible. So if you can help us out, become a premium subscriber today, breakingpoints.com, or the link is down here in the description video. It really means the world to us, and if you like what we're all about, this is the best possible way to keep us 100% independent, working only for you.